sufficiency, you properly allege maritime negligence. So if defense counsel files a motion to dismiss, it's going to be subject to the federal rules of civil procedure as to whether, the complaint is sufficiently pled, whether the claim is plausibly pled. And as you'll see, if the complaint is difficult to discern based on the form or the substance of the complaint, it may be dismissed as a shotgun pleading. Now, just going over briefly the federal rules that apply to these types of motions to dismiss. Federal Rule of Civil Procedure 8 requires a short and plain statement. Oh, 1 second, let me pull up the presentation. Okay. Federal Rule of Civil Procedure 8 requires a short and plain statement for the jurisdiction, short and plain statement of the claim, and then a demand for the relief sought by the plaintiff. Under Federal Rule of Civil Procedure 10, in particular, subsection B, paragraphs, a party must state its claims or defenses in a numbered paragraph, each limited as far as practical to a single set of circumstances. A pleading may refer by number to a paragraph in an earlier proceeding, and each claim must be founded on a separate transaction or occurrence. And this includes affirmative defenses and denials, and they must be stated in a separate count or defense. So this is going to come up later when we look at how courts review shotgun pleadings. Federal Rule of Civil Procedure 12b6 governs whether a plaintiff has properly stated a claim. And it looks at Rule 8, and a court, when they receive your complaint is going to see if the complaint is plausible on its face. So the court is going to read your complaint as if all your allegations are true, and it's going to assess whether you've stated enough facts in order to plausibly state a claim for maritime negligence. But where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct, you haven't pled properly and you haven't crossed that line from possible to plausible. Now, the first 11th Circuit case that really took a look at a plaintiff pleading both direct negligence and vicarious liability against a cruise line was Holland v. Carnival Port, cited in 2022. In that particular case, a cruise passenger alleged that he slipped and fell on a wet substance while descending a glass staircase. And this is a very, very typical type of claim that's filed in federal court against a cruise line. And as part of the amended complaint, the plaintiff titled his claims as a vicarious liability claim for negligent maintenance and a vicarious liability claim for negligent failure to warn. So even though the plaintiff had pled his counts as vicarious liability claims, he included within those claims allegations of direct negligence because he included allegations of actual or constructive notice. So plaintiff alleged that Carnival had actual or constructive knowledge of the hazardous condition because its crew members failed to conduct sufficient routine inspections of the area and failed to maintain the glass stairs in a reasonably safe condition. And as part of the negligent failure to warn claim, it claimed that Carnival had knowledge based on its failure to post appropriate signs, markings, written or oral warnings. So even though vicarious liability does not require any type of evidence of actual or constructive notice, the plaintiff in this case had pled that as part of his vicarious liability claim. Carnival filed a motion to dismiss, stating that plaintiff failed to present adequate evidence of an actual or constructive notice of a risk-creating condition, and argued that plaintiff's conclusory allegations as to whether Carnival had notice of the specific hazard, the puddle on the staircase, was insufficient to impute notice to it. So at the district court level, the motion to dismiss was granted, and Judge Stola found that the plaintiff had failed to allege that Carnival was on actual or constructive notice of the hazard in question, and the factual allegations failed to satisfy pleading standards under Twombly. Held that plaintiff failed to provide any facts in support of the allegation that there were frequent prior slip and fall incidents on this specific glass staircase. When it went up to the 11th Circuit, they affirmed dismissal of the complaint. And in doing so, the 11th Circuit cited the pleading standards in Iqbal and Twombly, specifically that the plausibility standard is not akin to a probability requirement. The analysis is not formulaic, and in determining whether a complaint states a plausible claim for relief is a context-specific task that requires the court to draw on its judicial experience and common sense. So it's giving the district court some deference to see, you know, in the judicial court's experience, are these allegations actually going to cross the line from possible to plausible? And are the factual allegations merely threadbare recitals of the elements of the cause of action? Are they just conclusory statements to, you know, state the elements of the claim? You need more factual allegations. And so the 11th Circuit counseled that when a district court first reviews the complaint, it eliminates any allegations that are merely legal conclusions. So in reviewing the facts of Holland specifically, the 11th Circuit distinguished a claim based on a ship owner's direct liability for its own negligence versus a claim on a ship owner's liability for another's negligence. It stated these two liability theories are very different concepts, and Holland here improperly tried to blend them into a single theory of liability against Carnival. It lays out the standard for direct liability against the ship owner itself. And that, of course, is that the defendant, the ship owner, has a duty to protect the plaintiff from a particular injury, that the ship owner breached that duty, that the breach proximately caused the injury, that the plaintiff suffered actual harm. And with respect to direct negligence against the ship owner, within the maritime context, the ship owner owes a duty of reasonable care. That reasonable care standard requires, as a prerequisite to imposing liability, that the ship owner have actual or constructive notice of the risk-creating condition. The risk-creating condition is normally the puddle of water, the step, or the improperly maintained threshold. Thus, a ship owner's actual or constructive knowledge of that condition arises as part of the duty element. So you have to allege the ship owner's actual or constructive notice of the risk-creating condition as part of your complaint. In contrast, vicarious liability, this is imputed to a ship owner whether the ship owner is at fault or not. So when the tortfeasor is an employee, the principle of vicarious liability allows the ship owner who is not at fault to be held liable for the negligent actions of its employee and that employee's scope of employment. Now, in reading the allegations in the Holland complaint, the 11th Circuit found that despite the two counts being titled vicarious liability claims, there was nothing within those counts that led them to understand the claims as such. That's because the plaintiff did not identify any specific crew member that caused his injury. And at the same time, plaintiff inconsistently alleged that Carnival had actual constructive notice, which is not at all relevant to vicarious liability. So once the 11th Circuit decided that what plaintiff had actually done was lead direct liability claims against the ship owner, it analyzed whether there were sufficient facts regarding the ship owner's actual or constructive notice. On the appeal, the plaintiff conceded that it did not allege any actual notice, so the 11th Circuit addressed only constructive notice. In regards to constructive notice, that can be established by alleging that the defective condition existed for a sufficient period of time to invite corrective measures. You can also allege constructive notice by putting forth evidence of substantially similar incidents that occurred prior to the plaintiff's incident. In Holland, plaintiff failed to allege facts that cross the line from possible to plausible regarding constructive notice. Regarding substantially similar prior incidents, plaintiff simply alleged that there were frequently spills on the staircase and prior slip and fall incidents on the staircase. But the 11th Circuit found that this was not enough. It found that these allegations were insufficient and conclusory, and that plaintiff failed to allege any facts regarding specific substantially similar prior incidents. On the other hand, the court also reviewed to see if the plaintiff had alleged whether the condition existed for a sufficient period of time to invite corrective measures. In that regard, the court said that the inferential leap from Holland's premise that the stairs were highly visible and well trodden to the ultimate conclusion that the hazard existed for a sufficient length of time was too great, and that Holland's admitted complaint lacked any allegation as to how long the slippery transient foreign substance existed. So no allegations regarding how long that puddle of water existed in the area, and no factual allegations describing the substance that would lead one to believe that that puddle of water had been there for a sufficient period of time. Now, the 11th Circuit also addressed the USCO case that I discussed earlier. And it said, in analyzing the plaintiff's negligence claim, which was brought under a theory of vicarious liability in USCO, we held that a passenger need not establish that a ship owner have actual or constructive notice of a risk-creating condition. But USCO also reaffirmed that whereas here, a plaintiff is relying on a theory of direct liability for maintaining dangerous premises or failing to warn of dangerous conditions, plaintiff must establish notice as part of those claims. Went on to say that this type of case in Holland, where the plaintiff was alleging a puddle of water on a staircase, is one where the plaintiff is limited to a theory of direct liability. And unlike the plaintiff in USCO, Holland did not identify any specific crew member that eventually caused the injury. So in USCO, you have the dancing crew member that drops the passenger, but in Holland, you simply have a puddle of water on a staircase. The 11th Circuit stated that nothing in USCO suggests that Holland could avoid pleading the required elements for direct liability, which includes actual constructive notice, simply by titling his claims as vicarious liability claims.
Oh,
Now, following the Holland case,
yeah.
district courts started reviewing the allegations to see if actual or
One day at a time.
properly alleged and how vicarious liability comes into play. So one such case is Kendall v. Carnival Court. And in that case, a plaintiff alleged that he tripped over an unmarked, uneven, and unexpected change in elevation along the floor surface on deck one of the ship. And the plaintiff there.
I'm gonna start.
Which included negligent maintenance, negligent failure to correct a known dangerous condition, failure to warn of that condition, and negligent design. So Carnival moved to dismiss the complaint, arguing that the complaint did not sufficiently allege facts that show that Carnival was on actual or constructive notice of this unmarked, uneven, and unexpected change of elevation. And as part of the plaintiff's complaint in that case, it was alleged that there were 6 prior trip and fall incidents involving similar changes in elevation, that conclusively the dangerous condition existed for such an extent of time that Carnival should have known of it, and that Carnival violated industry standards relating to similar passenger walkways. So breaking those allegations of actual constructive notice down, as part of the complaint, there are 6 prior trip and fall incidents listed. And here in bold, we have an example of one. So it was alleged that in 2017, a cruise passenger tripped and fell on an uneven or sloped carpeted passenger hallway on the Sunshine. And in reviewing whether plaintiff properly alleged this prior substantially similar incident to overcome the constructive notice, the court said without any specific factual allegations, the court cannot conclude that any of these incidents were substantially similar to this case. First, only one of the prior incidents occurred on the actual vessel. And while that earlier incident occurred on a carpeted surface, there were no other facts to demonstrate that this incident was substantially similar to the one in this case. And then the court listed out a list of questions it had regarding this prior incident that was alleged. Was the dangerous condition similar or same to the one here? Where and how did the prior accident occur? Were there warnings about the change in slope in that prior accident? Did that prior accident occur in a high traffic area? Are there any precautionary actions taken by the defendant in that prior incident? And the list goes on. Now, the other allegation of constructive notice in that case was simply that the condition existed for such a length of time, and that we should have known about it because the condition was in a high traffic area of the ship. And the court said typically this is an argument that's reserved for a transitory substance case. So again, that would be a puddle of water on the floor. But the court said assuming such a theory is proper, the plaintiff has to demonstrate again specific facts regarding how long the dangerous condition existed and basically list out some type of time reference about it. Now, the third allegation of constructive notice was that the condition violated industry standards. The court said the violation of industry standards itself does not constitute notice of a dangerous condition, citing to another case, Francis v. MSC Cruises, and that the complaint here failed to identify which industry standards were violated, how and when the defendant violated them, and what relation to the industry standards this dangerous condition had. So that. Oh.
Can you hear us on the Zoom again?
Yep.
Yes.
Okay, thanks.
All
The
right,
internet went out momentarily. Sorry about that. Cooper, if you want to
yeah.
back it up 30 seconds and.
All right.
Oh, and also, if you're participating via Zoom, could you please mute yourself? We've been a couple of times, people weren't on mute. If you can mute yourself, thanks.
Right.
The sound went off when he was saying the third allegation.
Thank you.
Okay. All right, hopefully everyone can hear me and we're back. So just to rewind a little bit, I was discussing the third allegation of constructive notice, which was that defendant had constructive notice of a dangerous condition because of violation of industry standards. So the district court in Kendall said that the violation of industry standards alone does not in and of itself establish a notice of a dangerous condition. That's because the plaintiff failed to identify which industry standards were allegedly violated, how and when the defendant violated them, and what relation these industry standards actually had to the dangerous condition in that case. So in Kendall v. Carnival Court, the district court dismissed that complaint. Now, turning to Spots v. Carnival, this is an example of actual or constructive notice being adequately pled. In Spots, the passenger alleged that he slipped and fell while walking on the Lido deck of a ship, and 5 claims were brought against Carnival, all direct liability claims for negligent maintenance, failure to warn, supervision, negligent design and training. And in that particular case, the plaintiff alleged facts and said there existed a large puddle of water, 2 feet by 25 feet, that had accumulated and remained on the deck throughout the day. The court found adequate allegations of constructive notice. In that complaint, the plaintiff cited 2 prior lawsuits involving slip and falls on the Lido deck of the ship Pride. And in that case, Judge Altman said that the plaintiff's allegations of substantially similar incidents were sufficient. And I haven't listed all the prior incidents, in this PowerPoint presentation, but there was a good description of what had occurred in those prior incidents, and there are also citations to prior lawsuits. So that gives the court some assurance that there is actual prior incidents which are going to put Carnival on constructive notice. So turning to a case with a different factual pattern, Rosenberg v. NCL Bahamas. A passenger on board a ship alleged that he was using a sauna when a jet of steam struck his arm and burned him and caused him to start to fall backwards. He alleged that he sustained some burns on his arm, that he injured his wrist. And counts were brought against the defendants for failure to inspect, maintain, and service the sauna, and for failure to warn of the sauna's condition. And in that case, the defendants moved to dismiss because plaintiff failed to allege any facts to support how they were actually on notice of this dangerous condition with the sauna. In addressing those allegations, the court said, where a plaintiff's pleading could be interchangeably alleged against any cruise line defendant, the plaintiff has failed to adequately state a claim. So you can tell from the outset that this complaint likely did not have any factual allegations regarding actual or constructive notice of the dangerous condition of the sauna. The complaint provided no details that defendants knew or should have known of any malfunction. And the plaintiff provides absolutely no details of complaints or facts specific to the ship, the ship's crew, or even the defendants in support of his allegations. And you can't simply say that there were prior incidents or complaints without backing it up with actual factual allegations regarding those prior incidents or complaints. And also, the plaintiff argued in response to the motion to dismiss that his own allegations regarding his specific incident were enough to put the defendants on notice, which the court said was improper. As part of that complaint, there was also vicarious liability claims alleged, and the court cited to Holland and said that not only does the plaintiff fail to identify any specific crew member whose negligence caused the sauna injury, he fails to specifically allege any negligence by any NCL employee at all. So there, a plaintiff could not avoid pleading elements necessary for direct liability for negligent maintenance and failure to warn by again titling his claims as vicarious liability claims and simply asserting that the defendants are vicariously liable without any evidence of actual or constructive notice. Right. So turning to another recent case, Jones v. Carnival Corporation. In that case, the passenger was returning to the cruise ship after going to Grand Cayman for the day. He was returning via tender vessel. It was alleged that the weather started to become windy and rainy with the sea being stormy. And while disembarking the tender gangway to get back onto the cruise ship, the plaintiff slipped and fell backwards. And there the plaintiff asserted 4 counts: general negligence, negligent maintenance, negligent failure to warn, and vicarious liability. And the cruise line again moved to dismiss the claims. Now, in that particular case, the court found that direct and vicarious liability claims had properly been pled separately. But the factual allegations for the direct liability claims and vicarious liability claims were identical. So the court said the true dispute was whether the underlying factual allegations supported both direct and vicarious liability claims. Plaintiff argued that defendant was directly liable as a ship owner for its failure to prevent the gangway from becoming slippery, and also that it was vicariously liable for the crew member's failure to reasonably set and secure the gangway. So the Jones court held that these direct liability and vicarious liability counts were duplicative, and that was because, contrary to the plaintiff's representations, the crew member's breach of duty is premised on the same factual allegations that, accepted as true, give rise to defendant's direct liability. Specifically, the complaint alleged that defendants and its crew members breached their respective duties by engaging in 6 identical acts or omissions. So here comes the tension. Defendant is a corporate entity, and since an entity like defendant must almost act exclusively through its agents, the crew members' acts and omissions and defendant's acts are one and the same.